Ladies and gentlemen, distinguished guests, with a great pleasure, I welcome you to the second day of the fourth Cyprus Forum. Starting with our Fireside discussion on measuring the rule of law and values in Cyprus and Europe. I warmly welcome Stéphanie, Shaelou, Professor of European Law and Reform Director, Monnet Center of Excellence for the Rule of Law and European Values, Head of the School of Law at UCLan Cyprus, and Orla Drummond, Senior Research Analyst, Human Rights Lawyer. The floor is yours.
Thank you very much, Georgina. First of all, thank you very much for everything you're doing for us, for the Cyprus Forum. So on behalf of everyone, thank you to you, Nicholas, and the team for all your very good work. Welcome, Orla. Welcome to Cyprus. I'm so happy to have you here. It's the third time we meet this summer, so I'm very happy. Welcome, everyone. Thank you for coming on a Saturday morning, 10 a.m., which is not the best time. So let's talk about transparency. And let's talk about how measuring rule of law and European values is relevant to transparency. Now, as you heard, I am the director of an EU co-founded Jean Monnet Center of Excellence for the Rule of Law and European Values, which runs at the School of Law of UCLan Cyprus. And I'm very happy and grateful for the excellent discussions we've been having yesterday, and I'm sure we will continue today. So by way of introduction, I will present a few aspects of CRoLEV, which is the name of the Center of Excellence for the Rule of Law and European Values, CRoLEV. So what we try to do at CRoLEV with colleagues, it's not only me, of course, quite a few colleagues are present, is to provide insights on the states of the rule of law and other European values and principles in troubled times. In Cyprus, but not only. The threat to the rule of law has been taken seriously by the European Union. I think we can say that, and we heard it yesterday as well. This is evidenced by the development of activities around reporting, rule of law reporting, and mechanisms around the rule of law, soft and hard mechanisms. Yet, the current framework for monitoring and protecting the rule of law might appear inadequate, given the limitations on areas covered and the methods employed to measure the rule of law. Because when you measure, when you try to quantify a concept like the rule of law, then you have to make what we call in the research field ontological and epistemological choices. And those choices, they determine your methodology and therefore your results. So when you actually assume, for example, that, I'll give a typical example. The EU is made to become a political union. If that is your initial assumption, all your results and findings are going to be derived from that very same ontological assumption. So we work on the initial assumptions. We work on the initial assumptions. What is the rule of law? What are European values? What is the relationship between the two? Can you have a democracy that is not based on rule of law? These kind of questions. And then once we determine what is our theoretical framework, we then go to the empirical part and to the assessment and the measurement. So we believe there is a gap here to be filled, and CRoLEV would like to contribute to filling this gap by acting as an enabler of knowledge and proposing different frameworks and ways in which we can measure the rule of law and European values effectively, efficiently, and responsibly, and use empirical indicators to determine to what extent states like Cyprus act in ways that are compatible with the principles that we identify. So our methods take into account existing, of course, initiatives, formula, frameworks, mechanisms. Some of them were discussed yesterday including in the plenary at the municipal theatre. So those frameworks come from the EU, of course, from the Council of Europe, but also from the United Nations. And we work with all those recommendations, bodies of resolutions, regulations, but also indicators. So we work with those, we analyze them, we measure or analyze or examine their shortcomings, and then we create our own indicators that are more relevant to the ground, so are more relevant to specific contexts, like the Cyprus context, for example. So our ultimate aim would be to contribute to the development of a comprehensive rule of law and European values measurement system based on an agreed balance of objective and subjective criteria and unique methodology or unique or uniform methodology, combining the quality and the quantification of rule of law and European values in different countries. And this is something I think we will pick up in the conclusion with Orla. So using that framework will enable an analysis of rule of law, European values, parameters in Cyprus, because very often indicators for Cyprus are missing, qualifying and quantifying the extent to which the rule of law and other values are secured, and how, whether actors and mechanisms relevant to the safeguarding of the rule of law, such as institutions, civil society and governance principles, are sufficiently empowered and protected, because this is our ultimate objective, is actually to enhance and foster civil participation and citizen empowerment. So in one of our outputs, which is called a scoping paper, the CRoLEV scoping paper, which you can find on our website. Everything we do is freely available on the website. Just Google CRoLEV and you will find it. We explained in that scoping paper how we engage with empirical analysis of the rule of law and value aspects, including the way they work in practice and their effects on or the perception by ordinary citizens, stakeholders, and civil society in general. This analysis will result in qualitative and quantitative rule of law and European value reporting mechanisms for individual countries like Cyprus. And this will be supplemented and is being supplemented by innovative, interactive, and online tool in the form of a dashboard and an index, which will be available on the CRoLEV website very soon. So the novelty of the methodology here is to adopt, it's to complement research into a common rule of law framework with a collection of data, of unique data, new data, using various methods, combining qualitative and quantitative research, including through thematic research, thematic analysis, surveys, focus groups, and so on. Impact assessments as well, and recommendations. So to start the data collection and to write the scoping paper, we came up with fresh data, which we collected in the form of surveys and focus groups via the CRoLEV activities with civil society. And that allowed us, or enabled us to create to reflect on best practices already available on how to uphold the rule of law in Cyprus, but also to come up and design our strategy, the CRoLEV strategy. So the CRoLEV, the scoping paper, presents a detailed mapping out of existing data and a new data set with a view to create a renewed methodology for rule of law and European values placed within the framework of existing instruments, including SDG 16 on the rule of law. Out of this methodology, we came up with several pillars and sub-pillars, our strategy, which we are going to focus on. And our pillars are extremely relevant to the Cyprus Forum, and this is why we are here. It will focus on measuring the impacts or aspects of rule of law and European values in civic engagement, first of all, through citizen empowerment and the protection and the promotion of civic space in Cyprus, which is very much needed. Secondly, we are going to look at democratic governance and anti-corruption measures and transparency in particular. So this is why we're having this panel now. Thirdly, at the functionality of justice in Cyprus and Europe. That means not only the administration of justice, but also access to justice. And finally, democratic values in Cyprus and Europe. We have chosen to focus on media freedom and public responses to crisis. Of course, again, very relevant to what we're going to discuss now. So basically, for all those pillars and sub-pillars, we have created a list of indicators and ways to measure those indicators. I'm not going to bore you with this, but it's available on the website, and we are working on it now. Now, let me say a few words on transparency before I turn to Orla. Basically, how we see transparency is as a broad concept, which is both a necessary precondition and a key feature of any democracy. And in the absence of transparency, which we understand as the release of information about institutions that is relevant for evaluating those institutions, citizens cannot engage in meaningful decision making and participate to meaningful decision making. Without a commonly agreed upon information base, people are unlikely to be able to participate to deliberations and debate. Yet, the effects of the lack of transparency extend beyond this to a declining trust in public institutions, and this is what we're going to discuss now. And civic distrust is often associated with increased apathy, disillusionment with democracy, and disengagement from political processes. Lack of civic engagement leads to misplacement of trust or public trust in private networks. We heard, for example, yesterday the strong relationship between having money and having a platform to speak. This is exactly what we mean here. Further diminishing satisfaction with democratic institutions. At its worst, it may bolster anti-establishment sentiments, which can effectively result in violations of the rule of law. So this is what we engage with, and this is how we look at it. And out of our initial data collection, just for me to give you one finding of the data, when it comes to public trust in institutions, particularly the judiciary in Cyprus, in our data, the participants reflected that 86% of them did not trust the judiciary in Cyprus. 86%, yes. So there is work to be done. If you're interested in the scoping paper, there is much more about this initial data collection. But let me now turn to my guest, Orla, because I have spoken enough, and to another EU-funded project, which UCLan Cyprus actually is involved in. Actually, we actually lead that one. It's a Horizon Europe project, a WIDERA project. It's a large, very interesting project called Prepared. And that project is about research in ethics and integrity in a global crisis, including pandemic, but not only, and how we can be more inclusive of marginalized populations in the process. So I will turn to Orla, and Orla may give a few words about the Prepared project, and then we will turn to the first question. Thank you, Orla.
Okay, thank you, Stéphanie, and thank you to the Cyprus Forum for inviting me along to speak. I'm currently working for Prepared, as Stéphanie said, and we're developing an operational framework on research ethics and research integrity for use during crisis and emergency. And it's a global consortium, it's not just based in the EU. So our partners come from South Korea, India, China, Africa, and the whole way across Europe. So it's quite a large consortium of people working on this development. And we've lots of different organisations that are involved. So UCLan Cyprus leads it. We also have ICLAIM involved. UNESCO's one of the key partners, and Trilateral Research, who I work for. And my job has been to conduct the legal and human rights analysis for the project. So looking at the wider picture in terms of research ethics and integrity. And it has three key strands. So I've looked at the rule of law and administrative law and the development of emergency legislation. And I've also looked at certain fundamental rights that were impacted during COVID-19. And then finally, I looked at the rights of marginalised communities. So that's
Thank you very much, Orla. So here we go. Why must the rule of law be sustained in times of emergency in democratic societies? Can the sustained compliance with rule of law principles assist in crisis and emergency situations? What is the role of societal empowerment and democratic legitimacy in emergency responses to crisis, and how?
Well, I was very lucky to be here yesterday to hear about the different panels and what they had to say in terms of different elements of the rule of law. So we talked about the Attorney Generals and lobbying and different elements. But for me as a human rights lawyer, the rule of law is essentially about the protection of fundamental rights and freedoms. And this is particularly important during times of crisis and emergency, because during those times, marginalised communities are negatively and disproportionately impacted by those crises and emergency. So for me, a strong and robust rule of law is a necessity, it's not a luxury. And I would argue that the rule of law needs to be bolstered during times of crisis and emergency, and it should form part of states' responses, as it provides a strong and valid basis to respond to any mitigation measures that would be needed. For me, societal empowerment is so important in that process to foster trust in any kind of health-related aspects, if we're relating it back to COVID. It's vital that citizens have a really clear understanding and oversight of the laws that are being created during crisis and emergencies, so that elements such as transparency, participation, engagement are all an essential element of any response mechanism by any state. We saw an erosion of trust during COVID-19, I think. There was a massive mushrooming of mis and disinformation that was bandied about, as they'd say. And it wasn't just in relation to the development of vaccines, where there was high scepticism in certain communities. We also found that there was scepticism towards democratic institutions as well, and this kind of conspiracy theory that we were being harmed by the people who were supposed to be protecting us. So I think that ultimately a strong rule of law helps us to combat against that, Stephanie.
Thank you very much, Orla. Even if all rule of law principles are most important, as we heard right now, to uphold in times of crisis in democratic societies, and given current backsliding of the rule of law, which principles should stand out first and last as the last rampart, and why?
Okay. So for me, I feel that all elements of the rule of law are they're interdependent, they're co-related, and they're indivisible as such. So if you start creating a hierarchy of principles, then you're going to, you risk unsteadying the foundations of the principle and the rule. So for me, it's very hard to pick one or two. But I'd just like to say that during COVID, we saw really serious issues that impacted the rule. So with the rise in executive power without any scrutiny, which was really concerning, the pace of legislation, the rapidity of that, and the impact that that had. There was definitely an absence of planning. There was a lack of transparency, which is really what we're talking about today. There was an absence of any consultation process. We also saw a rise in interest groups and lobbying committees. And then we also witnessed subpar legislation, so we had loopholes and issues with drafting. And we witnessed the criminalisation of what would normally be considered just normal human behaviour. So I think we need to take the learning from that and ensure that key elements of the rule of law are adhered to, and in particular that is transparency, clarity, participation, engagement, and representation.
Thank you very much, Orla. So let's turn now to how can rule of law principles and values best support the democratic process of lawmaking and legal scrutiny in public health crises and other crises. Are there any rapid intervention mechanisms that need to be put in place in times of emergency, which is the topic of the prepared project.
Yeah. There's been a number of suggestions, Stephanie. The first being that any legislative or legal response is proportionate and it's time-bound, and also that this type of emergency legislation is distanced from any other national legislation or ordinary legislation just because it's temporary in nature. The Bingham Centre on the Rule of Law set out guidance for the development and enactment of emergency legal powers within democracies. So they said that there's a need to spot and fix mistakes before they occur, so that really tight scrutiny during crisis and emergency periods. Also, wider dissemination of the rules for public engagement to restore trust. No erosion of the rule of equality before the law. So political elites should have to be bound by the same laws as everybody else. I think that's really important. So,
in case of emergency, is it time for the state to scrutinize every step they make to save the emergency?
yeah, I would argue that that's a time for more scrutiny so that they don't make mistakes, so they're not rushing through legislation and then potentially impacting the fundamental rights and freedoms of their citizens.
In the COVID period, how much time they had to deliberate all the...
Just get the mic because people are online as well.
It's
Here.
a small room here, it's not...
Yeah, but there are people online.
I mean, in the COVID time, what time the state had in its hands to to scrutinize every step they could make against and to protect us?
Yeah, I understand that there was a need for rapidity and they needed to do it really fast, but you can't diminish the fact that you need oversight and checking mechanisms and scrutiny for legislation, because at the end of the day, if they've
Do
just...
they have time to put legislation?
Yes, so that's why the question was about rapid intervention mechanisms, because this is what we need to create, reflecting on COVID.
Mechanism is a group of people. Imagine one group of people sit down and talk about what the right thing to do.
Mechanisms are institutions too.
Yes, of course, but it consists of people, of some scientists, some experts,
Yes.
and to come together to make a decision. Imagine 10 people in every country or in Europe to sit together and try to scrutinize what you said. Scrutinize every step that could be against the human rights.
Yes, so basically what we're saying is that even if we are looking at rapid decision-making, rapid response to crisis, and usually from the executive, what we are saying is that there must be some sort of mechanism so that in this rapid response system, you actually consider specific elements of rule of law. This is what needs to be done. And this is what we are working on in the prepared project. But if you don't mind, we'll continue, because there is one more question which is probably of relevance to... Of course, yes. Yes, but... Yes, right. But we have more questions, so probably we will answer partly what you wanted.
Okay. No, that's fine, Stephanie. Do you want to go on to the next
Yes,
question?
so let me turn to the next question then. Which is on the relationship between emergency laws and human rights and citizens' powers. So, and exactly what we were discussing now, what we were discussing is called due process. So, due process requires, number one, time, which we don't have in crisis, and number two, emergency measures that are deemed temporary and subject to public scrutiny. So that's exactly what this discussion was about, which we can continue over coffee. So how can one ensure that a rapid intervention mechanism upholds the rule of law, fundamental rights, and democracy? Orla?
I don't think there's any simple answer to that, Stephanie. I think that COVID itself was a real stress test for the rule of law. and it put systems and governments and legislators under severe pressure. But I think if we keep to the basic principles of the rule and adhere to those as best we can, like deliberative debate and scrutiny are, required. They are, you can't really take that away just because you've got a crisis and emergency situation. Legislation has to be drafted in the correct manner. It needs to be clear. It needs to be widely disseminated to citizens so that they understand the law. I think what happened with COVID was that people were so quick to legislate or to make decrees or rules that people weren't actually aware of what the law was. Was it guidance? Were they supposed to stay in? What were they supposed to do with their kids in terms of education? There were lots of things that created this kind of diffuse atmosphere and environment that people just were not clear about the rule of law at that stage and the legislative powers that the government actually had. So I think that going forward we can take the lessons from that, learn how we respond to a rapid, with rapidity to any kind of crisis.
Thank you, Orla. So wrapping up, let's pause a second and think about the impacts of the phenomenon of deregulation that we're currently witnessing, partly because of emergency laws that are primarily temporary and at the discretion of the executive, and the impacts of deregulation on emergency powers and crisis situations. So what are the key characteristics of COVID-related legislation or any other crisis-related legislation resulting in obscure and arbitrary emergency lawmaking powers? What were the characteristics and what is the impact? What was the impact on vulnerable societies or groups? And what lessons can we learn so that we are better prepared for the next crisis?
Yeah. Well, I think prior to COVID-19, we witnessed a rise in that deregulation and anti-government sentiment, not only here in Europe, but across the globe. And the obvious example when you're reading academic literature is the Trump administration and their deregulation policies and anti-government sentiment that kind of stoked up. And you can also look at Brexit as well, in terms of the fact that at the beginning of Brexit, they were pushing that it was essentially about getting away from European regulations and creating their own laws, which didn't really work out that well for them. But I suppose what happened with deregulation is that we saw a real impact in public services and support services for the most vulnerable members of our community and society. In Prepared, we've done some research around frontline workers and the impact of cuts and deregulation within the health service and how that impacted people's ability to access healthcare during COVID. So I think really the most vulnerable members of our society were basically abandoned. There were no support mechanisms for them. And I think that COVID itself gifted authoritarian governance the possibility to rule by decree in certain states. And I think that that's something that, coming from a democratic position, we need to consider going forward.
Thank you very much, Orla. So we are done. I don't know if, Georgina, we have a couple of minutes for questions. I don't know. That's up to the organizers. We're running out of time. A couple of questions? Yeah? Okay. There's a gentleman here at the front.
Thank you for an interesting discussion. A couple of questions, one on rule of law, one on human rights. Rule of law seems to be countered now by people advocating for democracy, saying why should unelected bureaucrats be able to impose their will over the will of the majority, as should be in a democracy. That's the case in was the case in the United States, case in Hungary, and other places as well. How do you see the challenge do you see majoritarian democracy and populism as a significant challenge in the EU to the rule of law. That's one. And with regard to human rights, there's a lot of shift toward communalism, toward groups identifying, you can see it in Cyprus, whether the two different communities here. Are human rights better safeguarded by dealing with rights for communities or rights for individuals safeguarded by the state?
Thank you. That's very nice and kind of you. Could you say who you are, just for the sake of recording?
My name is Andre Goodfriend, a former U.S. diplomat.
Okay, thank you very much. I'll take the first one, you take the second one. So this is, of course, very relevant to what you're, to what you were saying. So the background and origin of the Jean Monnet Centre of Excellence for the Rule of Law and European Values is another EU-funded project on populism. So this is how we actually decided that it was time to bring to Cyprus a first Centre of Excellence in the field of European legal studies, focusing on the rule of law. So yes, we have done a lot of research on populism and on the impact of various forms of populism and the relationship with the rule of law. It is extremely important, particularly because of the various forms that populism can take, particularly digital populism. In the Centre of Excellence, we do a lot of work on the relationship between rule of law and other values, which are, of course, democratic values. And indeed, we are reflecting on the possibility of having one without the other and how that works. Because you could say that in Europe, we actually have at the moment some regimes, which are called perhaps illiberal democracies, somehow, where the two are disconnected. Rule of law seems to be disconnected from democracy and from democratic values. So this is for us very important. Thank you for the feedback, and we will work on that. Thank you.
Yeah, and I'll keep this really brief. So traditionally, human rights would have been about the relationship between the state and the individual, and it was always that way. And we have seen an increase in this kind of communal rights, as you say, and particularly in terms of minority rights and groups. And I think really on a personal level, I feel that there's space within the human rights fora for both. It's best protected in both for the individual, but also in the collective. So I don't have any issue with that. Some people do have, but for me, it's more about justiciability of rights and how people can claim access to justice in relation to them. And human rights kind of finds that a difficult kind of discussion. So.
Thank you very much, Orla. I think we run out of time. Unfortunately, we would have loved. We can, continue discussion now, but we have, I think, to give the floor to the next panel. So thank you for being with us, and thank you for listening, and thank you for your comments and questions. Please feel free to get in touch now if you would like to continue the discussion. Thank you.
Thank you.